can hear us. This is Chris Thrutchley. I'm the lead employment lawyer for GableGotwals Labor and Employment Law Practice Group, and with me is Tom Vincent, who's a member of our Labor and Employment Law Practice Group and also the lead of our Cybersecurity Practice Group. And as we were going through 2016, and as 2016 progressed, there were a number of policy-related regulatory changes that were evolving and developing that we were helping employers plan and prepare for, that ultimately, as the Trump administration came in, we realized that a lot of these new policy developments, a lot of the regulatory activity that was taking place likely wasn't going to come to pass. Also, some were blocked at the late last year through litigation resulting in injunctions. So we were helping folks deal with the new FLSA overtime regulatory changes that were taking place. We were helping folks with changes to the OSHA regulations. And we were helping folks get ready to comply with the new EEO1 comp disclosures. But all of that appears to be on hold, and more likely than not, most of us anticipate that the regulatory waters and the enforcement agencies' activity will likely be slowing down for 2017 and for the near future. So what are those critical policy and training issues that employers should be focusing on for 2017? And that's what we'd like to address with you over the lunch break today. Tom's going to talk about critical cybersecurity issues. I know just from staying alert to employment law commentators and human resources commentators, cybersecurity has been a hot button issue, Tom.
That's right, Chris. And as we've seen over just the past year or two, there has been an expansion in the recognition of the risks as well as the different types of dangers that are faced by employers and also individual employees. So what I'm going to be talking about today as part of this presentation is really not only just to give you some idea of the environment of cybersecurity issues and what employers and employees are dealing with now, as well as some of the tactics that have been and continue to be used to try to break through that security. Also, I'm going to give you some practical steps to put in place both at a company level and at an individual level. As part of my background, I was in banking and financial institutions for a number of years and managed different groups of people, had to hire and fire and conduct performance reviews. And a lot of what you're going to see here comes out of that experience in dealing with employees who had sometimes less than stellar records when it came to information security, either intentionally or unintentionally. And this should give you an idea of how to address that with employees and also ways to put some of these protections in place to assist them in assisting you. Chris, what else are you going to talk about today?
Well, as our topic slide reflects, in my opinion, given the fact that we anticipate a much less robust regulatory environment that's going to generate new policy issues for employers to consider, I really believe, in my experience, that the most important thing for employers to be focusing on for 2017 and into the near term is just an aggressive, proactive, relentless pursuit of discipline when it comes to making sure that just basic block and tackle employment practices and policies are up to speed and that managers and all employees are receiving the kind of regular training that they need to be aware of those policies and know how to implement them and administer them effectively. I don't know how many of you are following March Madness. I typically follow March Madness. This year, unfortunately, my team is not in it, so I haven't been as attentive as I normally am. But most people know Coach John Wooden. John Wooden he's probably the most famous NCAA basketball coach of all time. He coached UCLA. He won 10 national championships in a 12-year period. I mean, it's just incredible. But part of the reason why he's recognized as having been so successful was because of his relentless pursuit of being extremely well disciplined in all of just the basic fundamentals. For instance, one of the things that he's quoted as saying, he said, "Failure is not fatal, but failure to change might be." And in my experience, having done employment defense for over 20 years, having been director of human resources for a number of years, seeing these things in the trenches, and then more recently having been the chief of the Attorney General's Office of Civil Rights Enforcement, where we investigated hundreds of complaints of harassment and discrimination and retaliation, I can tell you in my experience the number one problem that I see with most employers, but not all, is just a lack of good discipline when it comes to the basics, particularly when it comes to training managers and supervisors well with regard to harassment prevention or discrimination prevention, or the most frequently filed of all employment claims, retaliation prevention, or even giving managers and supervisors just even a basic feel for those lightning rod ADA or FMLA or workers' comp issues that they face in the trenches that they need to be alert to in order to minimize risk for employers. So then lastly, a core area of training that we offer, but that I feel like most employers are not as diligent in providing for their people, is just how to manage performance and behavior issues in a way that exercises care. And you'll see the acronym there for CARE, which basically stands for clear communication about expectation and consequences, administering and applying policies and procedures in a consistent, uniform, non-discriminatory way, and then R, regularly recording well those things that you do to demonstrate that you are implementing best employment practices, and then E, just evaluating how you're doing those things, engaging counsel, engaging HR professionals to help managers and supervisors walk through a minefield of employment issues in a way that minimizes risk. These are the basic areas where every employer should resolve to excel in equipping their managers and supervisors to not only comply, but to do things well to minimize their risk. So I feel like it's critical over this next year, over the near term, for employers to really focus on doing well in these areas. Wooden also said this. He said, it's the little details that are vital. Little things make big things happen. And you know, most of the employers that I coach and counsel, most of the employers that I defend, do not regularly provide these types of training for their managers and supervisors, and they tend to think it's a little thing. They don't have time for it. How are we going to be able to implement this for all of our people? And they just don't exercise the discipline in making sure that it happens. But it's a vital thing. And every charge of discrimination, harassment, or retaliation I get, every case that we defend, we are striving to look for all of the things that an employer does to demonstrate that they're going above and beyond to minimize risk in these areas. And the absence of training is very hurtful to their defense. And so these are the things that we're going to cover in my section of the training today. If you have any questions, we're going to try to leave questions for the end. You have a button on your screen where you can submit questions as we go throughout, and as we have time at the end, we'll be glad to try to deal with those questions.
All right, so to start, I wanted to pose the question, what is cybersecurity? Because it means different things to different people. And as we see in the attempts that are made for everything from electronic access to old-fashioned theft, what I refer to cybersecurity as is essentially protecting against, you'll see there, unauthorized access to or use of information or assets via electronic means, which is a whole host of things. It's not just limited to what we would consider breaking into a computer system or hacking. It also includes things like fraud prevention. For example, if an employee gets an email requesting them to do something that is not legitimate, we'll get into an example of that later on, as well as the misuse of appropriate access. An employee that has been given access appropriately to particular company information, but either chooses or inadvertently uses that information inappropriately. For example, if you have an employee that sends information home to work on it, when that information has been represented to the client, that it will stay within the firm, the company, the bank, whatever. And Chris, you've got another example, a more recent one to share, I believe.
Yeah, we had a client who called and said, you know, we've terminated a CFO, and we have reason to believe he may try to file a claim against us, and he has asked that we return to him gigs worth of personal digital photos that he kept on his work computer. And amazingly, the client was very scrupulous in reviewing that information before considering whether or not to turn it over to the employer. And their IT department discovered that this CFO had been embedding confidential financial information into his digital photos with the apparent intent to steal those as he was departing. And so to me, it just stood out as a great example of how a client was very alert to the possibility of misappropriation of company information through this exit process and acquiring, quote, personal digital photos off his computer.
Right. Really quickly, just want to do a quick technical check here. If you could please click the hand icon if you can hear us. We want to make sure that everybody can hear and understand what we're saying here. So, okay. With respect to the particular tactics I mentioned earlier, what are we trying to protect against? Well, I would imagine that just about everyone on this call has been subject to a phishing attack at some point. If you've ever gotten an email from a bank where you didn't have an account, if you've got an email indicating that you've got a package that you need to log in and claim, chances are that's been a phishing attempt, which is a broad net cast to capture not everyone that receives it, but even just a small percentage in some cases can be profitable. A more targeted effort is what we refer to as spear phishing, which typically uses particular information about an individual target. We're seeing more and more spear phishing that is fueled by information available in social media, information about individuals' families, jobs, employment, education, any details that can be added to a communication in order to fool that employee that there is a familiarity or a connection that there's really not. Spoofing is another tactic in which a URL or a website is set up under a name that appears to be legitimate or appears to be one particular address but is in fact another. We've seen, for example, email addresses that have law.com in them. At times, the criminals will use lavv.com, which appears to be the same if you look at it on a mobile device or don't pay much attention to it on your computer, but is in fact a completely different URL, even though it may have the actual credentials from someone that works for the legitimate company. Similarly, I saw this a lot when I worked in banks, are emails that come from customers, legitimate email addresses, but because that customer may not have followed appropriate protocols, their email address has been hacked and compromised and being utilized by a criminal who is requesting, for example, money be sent to an account that does not belong to the actual customer. And unfortunately, I've seen employees with decades of experience fall victim to these emails and end up losing their jobs because they didn't take sufficient precaution to ensure that it was actually the individual customer that was making the request. We're seeing this more now also, not just from clients, but from vendors requesting immediate payment of an invoice that doesn't exist. And then lastly, you'll see there loss or theft due to inside actors. Chris just gave a great example of that. But we also have seen incidents of loss where, as I mentioned, information may be sent home. There was a recent case a couple of years ago where someone had left an employer and emailed to his home a list of customers. Well, unfortunately for this individual who was intending to provide this to a subsequent employer, his home computer was hacked, and the foreign hackers took that information and sold it online. So you'll see there at the bottom where it says not all require hacks. Not all of these require any forced entry into a system or any sort of advanced technological knowledge. At the end of the day, some of these are just good old-fashioned fraud, and they depend upon the assistance of employees, willing or unwilling, to help them commit this fraud. In addition to those tactics, we're seeing more and more the use of ransomware, which is a program that goes in and encrypts data on a system. Typically, it will either lock someone out of a device, block access to a particular file, requesting ransom be paid. I've seen a couple of different instances lately where there's a particular email that's sent, or in some cases, if it's an automated attack, the files, if you click on the files, that's when a notification will come up that says to restore your information, email us at this address, and then that's when the request for payment is made. As you'll see there, in some instances, those files are posted to the internet. In many instances, the information isn't actually breached or leaked out. It's just the access is taken away. And then finally there you'll see at the bottom, in the first quarter of last year, there were about $210 million in ransom paid as a result of ransomware, and the estimate is that last year it was $1 billion industry. So
we're in the wrong business.
So what is the goal here? I mean, why do people go through all of this trouble to encrypt data, to steal the data? Well, there is real value, both from personal information and company information. Also, in some instances, we're seeing not so much a commercial reason, but a personal reason, whether that is a desire for social outrage at a particular issue. One that we're seeing more and more is just a desire to disrupt. For example, in Europe, there have been some utilities where their power grids have been disrupted by hackers just to create confusion. And then lastly on there, individual embarrassment. For those of you that aren't familiar with Ashley Madison or that situation, Ashley Madison is what we refer to as a relationship facilitation website. Their slogan is "Life is short, have an affair." And not long ago, their website was hacked, and the account information of individuals that utilized their services were placed online. And I have there, don't rely solely on firewalls, because I've had some clients that I've talked to about this, and their response has been, well, they couldn't get to Ashley Madison through our firewall. Well, what ends up happening was, as with most things, there's an app for that. And the Ashley Madison app doesn't require going through a firewall. It's simply required, as some employees did, using your work email as your sign-on information. And I talked to a friend of mine who's an HR professional about this not long after it happened, and her comment was, you know, I'm really glad that we didn't have anybody that signed up for Ashley Madison. And my first thought, as I mentioned to her, was, well, that's really nice of you that you want to make sure that none of your employees were embarrassed. And she looked at me with a strange look and said, that's not what I'm talking about. I wouldn't want to be in HR for a company that had employees that were on Ashley Madison and have to field calls from the divorce lawyers that would be calling me wanting my company's email records, given that my company was used to facilitate this affair. So when we talk about value, again, we're talking about real money here. With respect to personal information, a common category is healthcare. You can see the statistics there. Important to note is that this information is worth about $20 a pop, and it's very useful for committing billing fraud. With respect to companies, non-public deal information is often targeted. I've got something from a couple of years ago that was an incident that ended up generating over $100 million in illegal trading profits. There were 32 defendants that were targeted by the SEC. This was in 2015, and just last year you may have seen that there were some law firms that were targeted from Chinese hackers that got in and similarly were able to get deal information through a spear phishing attack. And very briefly, talking about spear phishing and the tactics that I talked about before, very often those tactics are used in conjunction with each other. I went to see a hacker last year who gave this particular example of a company president that had asked him to break in and get via social engineering, which is essentially sending a request to an employee under the guise of a legitimate email. And the hacker ended up targeting the company president, and he did so by going onto the company's website, using the company president's photo, doing a reverse Google image search and looking for where else that picture had been used, and he found it had been used in a conference. He went to the conference website, picked someone at random from that conference, and then constructed an email via a spoofed email address to that company president, asking for his assistance in this website this person was developing using descriptive language about the company president's presentation. And within 24 hours, he did all of this. The company president clicked onto the link of the website and the email attachment, and his computer was automatically infected with malware. So again, this is something that happens through multiple channels, and that's why the multifaceted approach that we're going to talk about is really important. So we've got more valuable information, we've got more ways that people are trying to get it. Recognizing that, there are increased requirements from both state and federal authorities with respect to this sort of information. At the federal level, we see particular protections both for types of information as well as industries. I've got a couple of examples there. HIPAA regarding protected health information, Gramm-Leach-Bliley regarding financial information. And just be aware that HIPAA is not limited to hospitals or what we traditionally think of as healthcare providers. In a prior life, I was the HIPAA compliance officer for a bank because in the bank's capacity and the services that it provided, it actually was subject to HIPAA requirements. And then in addition, as you see there with respect to state laws, certain state laws require steps in advance of any sort of security incident, often affirmative protections regarding assessment of the risks to that information. And keep in mind that the coverage of a state statute is tied to the state of residence of the individual who is affected, whose information is breached. It's not tied to the location of the breached company. I have a client here in Tulsa that lost a laptop with information from clients in 5 different states, so we had to go through each individual state statute. We ended up settling on the most restrictive state statute and applied it to all of those clients requiring notification. After the fact, when we're dealing with a breach, there's still no federal breach law. Most states have something in place. However, those may vary according to the definition of what a breach is and what the definition of personal information is that triggers that analysis. For example, in Oklahoma, personal information includes first name, last initial, and one of the other elements required is financial account information, provided that there is some sort of key or way to access that information. Other states do not specifically require that key be there. The theft of the account number, together with the person's name, is sufficient to trigger the application of that statute. Oklahoma also has effectively an effects test. In other words, it's not enough that the information gets out. There has to be a likelihood of harm. Not all states require that. Generally, these statutes are enforceable by the state attorneys general. Some require mandatory attorney general notification as well as notification of the credit bureaus if enough records are out. However, there is generally no minimum number to trigger notification. One person is enough. So how do you protect against this? All of this, this increased efforts by criminals to get this information, increased value of the information to the criminals, and increased requirements to protect it. Well, something that can really help you is to make your employees your first line of defense. And this is, in my experience, this is what I referred to as the three-legged stool of awareness, empowerment, and accountability. You tell them what to do, you make sure they can do it, and then you make sure that they do it. When it comes to awareness, it's important to have consistent company goals that are communicated not only to employees but to third parties. More and more information responsibilities are being offloaded either to cloud providers, to system vendors, to outside IT professionals, and it's important that anyone that is contracted with that has access to your information understands what your goals are. It's important to have particular policies and procedures. We'll get into the specific policies and procedures that are recommended in a bit, but it is important to have those to communicate those expectations and to provide employees with a way to meet those expectations. It's also important to have an incident response plan. When something happens, things move quickly. And as we'll get into in the next few slides, it's important to have what you are going to do in place and have everyone aware of it so that once things start happening, it's like a leak in your roof. You got to know what you're going to do to minimize the damage and to contain that leak. It's also important to communicate those company goals through, if this is appropriate for your company, things like public statements and internal and external marketing. The banks I've worked for, it's important from a public standpoint to make sure that the public is aware and your customers are aware that you protect their information and you take that seriously. And internally, reinforcing that with employees to make sure that they're aware this is not just lip service, this is something that we hold as an important element of our business. It's also important to make sure that whatever you put in place is informed by your risks and resources. I've had clients that have gone out and purchased canned manuals and canned policies that are often a bad fit for their particular businesses. Either they're too broad to cover some of the specific issues that are unique to their business line, or they're so narrow that there are important elements of that company's business that just aren't covered. But most important, implement whatever it is that you decide upon. Don't idealize it. Don't let the perfect stand in the way of the good. From a policy and procedure standpoint, these are some policies and procedures that I've put in place, that I've drafted, and that I've utilized in my prior life as well. That first bullet there, you'll see internal information classifications and required security. Know what information you have and how you should treat it and how it's required to be treated. Data access, we talk about both hard and soft access. Hard access is relatively easy. Everyone I hired, I had an IS access sheet that had a list of systems that they were to use, and I checked off, I want them to have internet access, email, accounting system access, things like that. It's easily tracked, it's easily restricted. Soft access is harder. Soft access, to give you one example, is the kind of access that someone has when their boss couldn't give them the raise that they wanted, but they wanted to compensate them instead emotionally by making them feel important, by giving them access to information that nobody else had. I had to deal with that in multiple occasions in prior lives, and that's much harder to track and restrict. The example there, restrictions on sharing information from secured systems. What you end up with is employees that have access to information but don't understand the gravity of it, and so they don't understand the appropriate way to take care of it and secure it. Similarly, with respect to acceptable use policies, making sure that it's clear to employees how that information can be used and how it should be accessed. And that includes, to use the Ashley Madison access, how can you use the company's URL? Because that is part of a company's information assets. And especially as more and more companies are moving to email monitoring systems and tracking systems that are impacted by the volume of email that flows through, it's more and more important to communicate to employees what they should and shouldn't be sending through your system. Similarly, on the email BYOD, making sure that the individuals who can move sensitive information are identified. Not everyone should be able to email sensitive information outside of a company. And not everyone should be able to bring a device into a company without some sort of prior screening. I will tell you, just something to make a note of for later in the year, a good time to establish or train on a BYOD policy is in the fall, because Christmas brings with it brand new gadgets and gizmos that people want to bring to work and connect to systems. And so it's important to make sure and get that training done in advance of that, so you don't have someone bringing a $2,000 laptop that will be great to play Netflix on because you can't connect it to the network.
So Tom, when I gift my old firm iPhone to my kid, should I go through you to make sure my GableGotwals data is removed?
I would go through both me and the IT person to make sure of that, because that is exactly the sort of thing that can result in a leak if that isn't appropriately purged.
Not that that would ever happen for anybody. No one hands down their iPhones, do they?
No, not at all. It's 100% recycling. And then lastly on this slide, you'll see, why is awareness important? Last year, we saw the first HIPAA enforcement penalty against a business associate. It started with the theft of an unencrypted smartphone, but as part of the enforcement action, the Office of Civil Rights of the Department of Health and Human Services that enforces HIPAA cited a lack of policies, including an incident response plan, and as a result, this business associate was hit with a $650,000 penalty. So once people know what to do, you have to give them the ability to do it. And to briefly touch on what Chris will talk about later on, training is essential, and not just on general issues, but specific regulations that apply based on someone's job function. They need to know this is why you have to do this. This is why you follow this procedure. Also, beyond company policies, we're seeing more and more particular contractual commitments from clients, either, as I mentioned before, from a HIPAA standpoint under a business associate agreement, or more broadly, requests for certification or specifics in engagement letters where clients have said, we want you to have these particular measures in place. As well, lastly there you'll see basic preventive measures related to computer, mobile device, and other IT. We'll get into that here in just a minute. Also, regularly test your employees, both from a physical security standpoint and a social engineering standpoint. Make sure that your employees don't have physical access to server rooms, things like that where information is stored. Social engineering is a great tactic to use because it's better that someone in your IT department find out that a particular individual is sensitive to offers of free Star Wars tickets, as a friend of mine at another company shared with me, than a hacker that could actually do some damage. And then, as I talked about before, it's important to train everyone on your incident response plan. Two things to take away from this that I want to highlight. Don't assume or indicate that something equals a breach. A breach is a defined term in statutes and regulations. I encourage and strongly suggest that my clients don't use that term unless there has been some affirmative determination that a breach has occurred. And then also involve counsel as soon as possible. In many instances, when you're dealing with an information security incident, people want to be helpful and they want to be honest and say things like, oh, I'm sorry, I left the door open, or I emailed that to someone I shouldn't have. Well, those are the sorts of discussions that you want your attorneys involved in, because that may not be the case, but if those communications aren't privileged, then should any sort of litigation result, they won't have the protection that they should have. And then I'm going to go through these next slides fairly quickly so we can get to Chris's piece. Reporting and committee structure and job descriptions are some other institutional tools that can be used to reinforce not only employee responsibilities, but to provide them with avenues to raise concerns, particularly with respect to job descriptions. More and more with sensitive information, we're seeing job descriptions that are tailored to identify that particular information that the employee should have access to. As regulations in particular information protection schemes have a need-to-know element based in them. And lastly, we'll talk about accountability very briefly. Internal monitoring through audits or IT reports of access can be very helpful, as well as to use the example that Chris used, after termination, having some monitoring of what an employee has placed where, whether it's in photos on the employee's computer, if there's any information that's able to be determined that it was sent somewhere else. I've had a number of instances where I've had to track down emails that employees have sent home. In some cases, 12 inches of paper once printed off of different company information that we had to go get. And then you'll see on performance reviews, I will say in my experience, the easiest way to get somebody to do something is to make sure that they are paid for it or not paid for it. In other words, if they don't do it, then they don't get paid. And baking these responsibilities into performance reviews not only reinforces them, but it gives that employee a stake in those activities. And then lastly here for my section, before we get to Chris, I've got a list here that, if nothing else, for my section of this presentation, if you just tear this out of the presentation and set it by your computer, these are some basic things that can be done to reduce the risk of the sorts of things that we talked about earlier from happening. A couple I want to highlight very briefly. Turn off Wi-Fi unless you need to connect to a particular network. The hacker I mentioned earlier showed us a device that he ran for about 10 minutes in this hour-long presentation that I attended, and with that he was able to capture 6 or 7 phones because this router that he used mimicked public Wi-Fi signals, and these phones automatically connected to it because they thought it was a public Wi-Fi that they'd already connected to. Similarly, with respect to external hard drives and thumb drives, make sure and scan any information before you upload it. More and more resumes are coming in, for example, with embedded malware. Microsoft Office files are especially sensitive to it. And it's a good way to let something in despite all of your other efforts if you're uploading a file that has something hiding in it. And the last thing I'd like to say is, with respect to these measures and some of the other things that I've talked about, I was fortunate enough before he was killed to have a chance to meet and attend a sniper camp with a gentleman named Chris Kyle. And one of the things that Chris told us when he was teaching us was the phrase "aim small, miss small," which some on this call might recognize from the movie The Patriot. And I want you to keep that in mind when you're looking at these things, because these are not large-scale efforts. These are small things that are easy to implement and that can have big payoff. You know, we're not talking about completely restructuring your system. We're talking about applying common sense diligence and vigilance to make your company and your person less convenient to attack than someone else, which in this day and age sometimes is the best you can hope for. And with this, this will help you get there. Chris?
All right. Thanks, Tom. Well, we had one question so far come in on your section, Tom, and I'm going to go ahead and pop that off to you. Should companies limit employee access to corporate systems via home computers and smartphones, since it can increase the risk of being hacked? Should companies limit that kind of access?
I would say to some degree, yes, some limit is desirable, even if it is the limit, for example, that home computers that are accessing networks have to be outfitted with particular antivirus programs. I've seen a number of companies do that. Also, companies with respect to working remotely often require the use of a remote desktop protocol. So there is a particular gateway that is used rather than bringing information home that can live on a device that is less secure. With respect to smartphones and other devices, typically if those devices are encrypted, then the risk is lessened. But I will say that with respect to information that goes through email, this is exactly why we recommend that if any email that contains sensitive information, PHI, non-public information under Gramm-Leach-Bliley, that those emails should be encrypted. Because even if your company encrypts emails in transit, it may not encrypt it where it lands. So you could have something that is perfectly safe until it gets to an employee's smartphone at their home, that where they're able to open that file up in an unprotected fashion. And also keep in mind that typically in smartphones and mobile devices, if you open a file, most of us, I know I do this, when I want to look at that file in better detail or actually work with it, I have to open it inside an application in my device, which creates a copy. So now you have an employee with a copy of perhaps personnel records or sensitive medical information that is walking around with that on their device. And one last thing I'd like to mention that I didn't go into specifically with respect to access is always, whenever you have lateral moves of your employees, when you've got an employee that is moving from one department to the other, it's a good time to revisit their access levels, because what you don't want to have happen is a situation where you've got an employee that has been in payroll for years but has shown initiative and moves to a sales position and then is recruited away by an unscrupulous competitor who gets that employee, because they still have the access to payroll information, to bring with her information about what you're paying your people. So as you are maintaining access levels for your employees, make sure that those are appropriate for the position that they have. All right, Chris?
Thanks, Tom. In my experience, the vast majority of risks that employers are going to face come back to three basic things: harassment, discrimination of some type, or retaliation. The majority of the types of issues I'm helping employers deal with are in those basic areas. And so the necessity of regular training is crucial, and to the extent employers are not doing that, they really should double down on doing that this year and beyond. And one of the reasons for that is a case that I have highlighted in the materials on this slide, the Cato case, which came out of the Fifth Circuit, which, as most people know, the Fifth Circuit's a pretty conservative, one of the more conservative circuits in the country. But prior to the Cato case, most of you are probably familiar with the twin Supreme Court cases that came down in '98, the Ellerth and Farragher cases, which basically established for employers the ability to have an affirmative defense to harassment or now even discrimination claims if you can show that you exercise reasonable care to prevent and to correct harassment or discrimination or retaliation from occurring in the first place. And so what Ellerth and Farragher established is that ways that you do that are to implement up-to-date, thorough policies that cover the issue, but also to educate managers and employees about those policies. And this was established way back in 1998. I remember at that time, when I was the Director of Human Resources, we established training in this area for employees all throughout our organization. We had over 100 locations where we would go out and conduct live, on-site, interactive training for managers and employees. And doing that live, on-site training was very impactful. And a lot of great fruit that comes out of actually conducting your training that way. You learn so much about what's going on in the trenches in an organization when you actually roll up the sleeves and you get out there with folks and conduct the training live that way. But I am just constantly amazed as I deal with cases over the years since then at how few employers are actually providing this kind of training on a regular basis when it's really not that hard to do. And compared to the risk, the cost is so cheap compared to even the cost of defending one claim. You know, just recently, for instance, a case where a manager is interviewing an accounts payable candidate. And in the course of the interview, the manager asks, well, how is your health, by the way? Well, just a small amount of training would have educated that manager that that kind of question is totally off limits and could have saved them the expense of having to defend that charge that came in. Or one that was even more shocking to me, where the hiring manager actually wrote on their candidate interview form, sounds too, like a certain race, referring to the way that they spoke. In that case, settled fairly quickly, as you might imagine, with the smoking gun evidence that they documented themselves. A small amount of training would have went a long way to preventing that kind of thing from happening. Or a termination letter that was written by an executive that said, because of your rheumatoid arthritis, we have decided to end your employment. Well, again, just a small amount of training could have helped that person avoid a clear ADA claim. And so just important and easy to roll out the kind of training that can help prevent that kind of risk. But what makes the situation regarding the necessity of training much more imperative today is this Cato decision that came down just late last year out of the Fifth Circuit. And Cato basically stood for the fact that you need to train not just your managers and supervisors, but all of your employees. So in Cato, you had a situation where a clerk had made an internal complaint of harassment by a supervisor, and HR did the right thing. They immediately responded to the complaint. They conducted a thorough investigation of the complaint. And in fact, during the course of the investigation, they interviewed co-workers who were potential witnesses. And one of those co-workers, Mrs. Poland, testified, yeah, I observed this supervisor engaging in harassment, and by the way, I got harassed too. Well, Poland had never made an internal complaint of harassment. But as a result of the investigation, the employer did the right thing. They imposed swift, severe disciplinary action to correct the situation. But shortly after that, Poland went and filed her own charge of sexual harassment against the Cato Parish School Board. And she alleged that over the course of a 2-year period previous to her being interviewed in the other employee's complaint, she had suffered harassment by this supervisor as well. And even though she had never made an internal complaint up to this point, the Fifth Circuit Court of Appeals ruled that because the school board could not present evidence that Poland was aware of their harassment policy, and because they couldn't present evidence that she had received training regarding the policy and how to comply with it, they reversed summary judgment that had been granted to the employer, forcing the employer to have to go back and conduct a jury trial on whether or not she had been subjected to harassment and whether or not the employer had exercised reasonable efforts to prevent harassment from occurring. The lesson is really clear. It's not enough just to train your managers on harassment and discrimination and retaliation prevention. You also need to make sure that every employee in the organization receives the appropriate degree of training in order to have an adequate defense. And that can go a long way toward reducing the settlement value of any claim that you may receive. So, of course, this kind of training that we provide the rank and file employee is different than the kind of training that we provide managers, but at the same time, you want to make sure that you have training for all of the employees in your organization. And to the extent you're not doing that is the degree to which you have risk. And I can tell you from experience, most employers aren't regularly training managers and supervisors, and even more are not training all of the employees in their organization. So it's critical, I think, for employers to focus on making that a key commitment in 2017 and beyond. Many of you may be aware, or if you're not aware, just within this last week, Kai Feldblum, who is one of the commissioners of the Equal Employment Opportunity Commission, recently spoke at the SHRM Labor and Employment Law Conference, and she spoke on recent updates that the Commission has issued in regard to guidance for employers on harassment prevention. And in her presentation, Commissioner Feldblum talked about the essential elements that every harassment policy ought to have. And this slide reflects those essential elements that a suitable harassment prevention policy ought to contain. We regularly audit employers' policies, and I can tell you that even within the last week, I've seen a policy that did not contain all of the elements that are reflected here in this checklist. And so having an up-to-date current policy is a critical block and tackle component of your best prevention practices. And so you're going to want to make sure that your policies are up-to-date and have all of these essential elements. But having the policy itself is not enough, and that's what the cases make clear. You also need to regularly train and educate your folks about those policies and procedures. So this Fifth Circuit case, had the school board been able to show that the plaintiff had received its policy and had received training regarding what to do in connection with the policy, summary judgment would have been affirmed on its behalf and it would have prevailed in the case. Settlement value is a lot less when you have a high likelihood of winning a case early, but when it goes to the jury, the settlement value skyrockets. So it's critical to make sure that you have not only a good policy in place, but you're providing regular training for everybody as well. When you actually do that, when you train not only managers and supervisors, but you train the entry-level employees as well, you go a long way toward eliminating frivolous or unfounded claims. A lot of the claims that we're even defending right now are claims that employees have brought because they felt like it was harassment when it really doesn't meet the legal definition of harassment. It's not really an unlawful harassment claim. The fact that a manager was proactive in trying to get an employee to meet job expectations isn't harassment, that's management. But if employees aren't provided some basic level of education about what constitutes legitimate harassment, what constitutes discrimination, what forms the basis for a retaliation claim, then you're going to get hit with or have a greater likelihood of getting hit with charges of discrimination that you're going to have to respond to or claims that really don't rise to the level of harassment or discrimination or retaliation. So doing that training for all of the employees to help educate them can help you cut off baseless claims at the outset. Training that we regularly provide employers, modules that we recommend are those that we have listed at our opening slide. You ought to be conducting harassment prevention training regularly. You ought to be conducting discrimination prevention training regularly. You ought to be conducting retaliation prevention training regularly. You ought to be making sure that your folks know how to deal with ADA and FMLA issues. Who do they go to when your supervisors and managers in the trenches feel like they have those kinds of issues brewing, and how do they spot them so they can help you make sure that they don't grow into a full-blown claim? Just fundamental areas of training that every employer ought to be conducting on a regular basis. And as Commissioner Feldblum pointed out last week, that is now the EEOC's expectation. With these new guidelines that they have rolled out, they expect these things itemized for you here on this slide. The EEOC's expectation is that this type of regular training will be supported at the highest levels of the organization. It's frustrating to me to go into training for a client and their top leaders aren't there. The executives aren't there. Maybe even the vice president of human resources isn't there. That sends a bad message. It's a message you don't want to send. And so the EEOC expects top leaders to be there. The EEOC expects the training to be conducted by folks who are qualified to do it. They expect them to be live and interactive because they have found through their studies that they are the most impactful forms of training. In my experience, I agree with that. Now, to the extent that you're doing your training by software or through some online system, that is better than no training at all. But to the extent that you can do live interactive training, I think that's much more effective for you. Plus, you see things happening in the audience that help you spot issues that you can immediately address before they blow up into full-blown problems. They expect you to use examples that are appropriate to your organization. That ought to be incorporated into your training. They expect you to deal with the reporting process. How are employees supposed to go about having their problems dealt with appropriately? And then lastly, as this last bullet highlights, and as I've emphasized throughout the webinar today, they do expect you to conduct the training not only for all employees, but regularly for all employees. Now, here's one thing that's significant about the EEOC's new guidance in this regard. You know who's going to rely on it? Plaintiffs' lawyers are going to rely on it. When you get a charge of discrimination or harassment or retaliation, EEOC investigators are going to rely on it, and they're going to go into investigations expecting that you're going to be able to produce evidence showing that you do these things. You want to put yourself in a position to be able to make that showing. You get into a deposition. What's going to happen? They're going to hand Mr. Supermanager a copy of your policies and procedures. And what does every one of your handbooks say, I guarantee you? In the intro, your handbook says our people are our greatest asset. Are they really? Your handbook's going to say you are genuinely committed to equal employment opportunity. Well, are you really? Then when you get into that deposition, they're going to be asking you, well, if you really care, if they're really your greatest asset, how regularly are you training your managers and employees to take care of harassment, discrimination, or retaliation claims in a way that really shows that you're trying to maintain a workplace that's free from these kinds of problems? And so plaintiffs' lawyers are going to rely on these new standards that the EEOC has rolled out, and so you're going to want to make sure that you're careful to meet these standards. And then lastly, our time's up. Just before we offer some time for a couple of questions, if we have any that come in, just a few things to wrap up. One, it demonstrates prudence, and it shows that you really care about doing the right thing, and it defeats any inference that you have a discriminatory or retaliatory motive. If you're reaching out to people to get help about matters that you're dealing with in the trenches, encourage your folks to reach out to HR, encourage your managers and supervisors, your HR, to reach out to counsel, to audit what your policies, to audit your procedures, to audit your training, and that demonstrates that you truly have an intent to try to avoid harassment, discrimination, or retaliation claims. And then lastly, we have other webinars that we're going to be putting on in the second and third and fourth quarter of the year that are designed to help you fulfill this commitment that we're talking about. In the second quarter, we're going to put on a webinar that's going to be dealing with brand new EEOC guidance that has come out within the last year that updates what employers need to be doing in the area of minimizing risk of pregnancy, paternity, and maternity discrimination claims. So we'll have a webinar coming out on that, and we provide training on that issue. Mental health discrimination. The EEOC has come out with new guidance in that area, and in the third quarter we're going to have a webinar updating you on that topic as well. And then lastly, the EEOC has also come out with new guidance on retaliation claims and minimizing risk of retaliation claims. We'll provide a webinar and training on that topic in the fourth quarter. So if you'd like a copy of our materials, you'll be able to download this PowerPoint presentation from the website. We'll also send out an email to you that has information on how you can get SHRM credit if you would like it. And what else do we have here?
Well, and I've got two questions here before we go, but one last, if you want to talk to him about the OKHR seminar really quickly also.
Yeah, first week of April. Many of you may know about the Oklahoma HR Association state conference that's being held in Norman. We have some speakers that will be presenting down there on different topics. Tom's going to be addressing best practices in cybersecurity for HR, and I'll be talking about how to manage performance and behavior in a way that minimizes risk of claims. And we'll have gender issues. Ellen Adams out of our Oklahoma City office will be addressing gender discrimination issues and latest developments in that area as well. Anything else? Do you have any other questions that came in?
I've got two questions that came in here. And again, our contact information is on the last page of the presentation right here. Please feel free to reach out to us if you have any questions that either didn't get answered during this presentation or you think of after we're done. The two questions I have here, one is best practices and advice for employers to manage elevated or privileged access. Well, I think that starts with the information that is being accessed and just a general policy that this information is limited to those people that need to know it. And then flesh that out with, depending on the level of privilege and sensitivity, up to and including a list of those individuals that should have access to the information. And that if someone wants access that is not on that list, that there's some approval process that's required. It's also important to have, for that particular access and that information, passwords and access information that is kept separate from that information. Many ransomware programs now will go in and open up files that may contain passwords that then the hackers can use to get into this information without any trouble. So it's important to keep those keys separate from the information that's locked up. And then lastly, what I would certainly recommend both for this issue and information security issues generally is some sort of regular certification on the part of employees. I've seen regular certification with corporate policies for years now, and I think this is certainly at the level where including that among those policies that is explicitly certified to is a good idea. And then the second question that came in was, for small to mid-sized businesses, what type of scan device or system do you recommend to scan external hard drives or thumb drives? Well, most antivirus programs contain some functionality like that. One I have worked with before is WebRoot, that is relatively easy to use and can scan files on a thumb drive relatively easily, or anything that is connected into the network. I'd certainly encourage you to talk to your IT people to make sure that whatever you use is not overly disruptive to your business processes. But again, whatever you use, some form of scanning is certainly recommended to make sure that you're not opening your system up to hazard with an unfamiliar device. All right. Well, thank you all so much for your time today.
And if anybody would like help in any of these areas, Tom and I are glad to help you in any way we can, and are glad to help with auditing any policies or procedures you may have questions about, or talk to you about how we can help you implement cost-effective, comprehensive training.